Hi, Lawrence LeBrocq, Managing Partner and CEO of Garces, Grabler LeBrocq. Welcome to Victim to Victory, the definitive authority in personal injury. Today we have the pleasure of having Mike Tomasino, one of the top workers' comp attorneys, not only workers' comp attorneys, one of the top attorneys in New Jersey, working with us today. This guy is a machine. He works excessively hard. He's a diligent worker, works 7 days a week, and he's going to do approximately $15 million in settlements this year for injured workers. Welcome to the show, Michael.
Lawrence, thank you for the introduction.
Now, let's talk a little bit about your motivation, why you became a lawyer, and why you've gravitated towards representing people that are injured at work. I know your dad was a union guy. Did that have anything to do with your strength and your ferocity and desire to do so well for your clients?
It did. So my father, like my grandfather before him, all were members of unions. My father had worked at a grocery store. Prior to attending law school, I had worked full-time in a series of restaurants spanning approximately a decade. So when I go to court, there are many other workers' comp lawyers who are third and fourth and fifth generation lawyers. And although it's great to be a legacy attorney, there's a little bit different of an understanding about people that are injured at work when you can use the tools. When I know how to operate a pallet jack or an immersion blender, I have a bit of a different understanding of the case. And I also believe it helps me empathize with regular working people, as I've worked a non-lawyer job as long as I've been an attorney.
Right. Now, let's talk about some of the people that you represent. When people think of workers' compensation, they think of an injury on the job. What are some of the types of cases that you're handling on a daily basis that originate from a workplace injury?
Certainly. There are a few, and actually the labor market is shifting quite a bit, as well the types of claims. Everyone is familiar with, the quintessential accident. Someone falls from a scaffold, they're struck by a pallet jack, whatever it may be. We handle these specific event accidents, and we do it routinely. We handle them for public sector workers, we handle them for private sector workers, union workers, even those that are illegally in the country. But we handle a myriad of other claims, occupational claims, essentially repetitive exposure or overuse from your time on the job. Bending and lifting related injuries, carpal tunnel, things of that nature. And there's essentially a new class of work-related injuries to where you see, and it stems from logistics, individuals who are ride-sharing, not just the quintessential the truck driver, the individual that shows up to a factory, picks up the keys from his boss, but individuals that are, say, operating for Amazon Flex, utilizing their own vehicle, those that work for Uber and for Lyft. So we handle all of essentially the entire array of accidents, but the type of accidents that we see now is very different than what we saw pre-pandemic.
Now, if somebody is injured on the job, what should they do?
Number one, you've got to report it. Always go to your employer, explain to them that you were hurt at work, request medical treatment. If possible, draft an accident or an incident report with your employer so there's proof that the injury occurred in the event that the employer or its insurance carrier later denies that you were injured at work. In the event that you're hurt and you need emergent medical treatment, go to the hospital. And when you're at the hospital, be honest with the physicians. You were injured and the accident occurred at work. Many of times what we see is employers will instruct individuals who are en route to the hospital to deny that the accident occurred at work. So in the event that you need medical treatment, be honest with the people who are giving you that treatment.
Now, why is it so important? And you mentioned in case the employer or insurance company denies you had that injury at work. So that stems together with the fact that the employer is sometimes instructs the employee to say the accident didn't occur at work. And what is the reason that it's so important to make sure you document this injury?
It's very important. One, New Jersey is one of only 2 states in the country that is not a directed care state. What I mean by saying that is not myself as plaintiff's attorney forward someone for treatment, but the insurance carrier has the right to control the treatment. New Jersey is also one of the very few states without a bad faith statute. What does that mean? There's essentially no ramification for the carrier or the employer in the event that the claim is wrongfully denied. So what happens many of times, people are hurt at work, and then either the employer or its carrier denies that an injury occurred, and in turn, the injured worker doesn't immediately receive medical treatment or money for their time out of work. So when you play it forward a bit, if an injury occurs at work and then someone subsequently denies that the accident occurred, there's a period prior to the retention of a lawyer where the person isn't receiving treatment, isn't getting money for their time out of work. The medical bills begin to pile up. So when you have proof early on that an accident occurred at work, it makes it much easier for me as your lawyer to go into court at the first or the second hearing and convince the judge that in fact an accident occurred at work.
Now, after that accident occurred, you were explaining briefly about the defense or the insurance company controls the treatment. Explain how that works in New Jersey.
Certainly. So in New Jersey, when someone is hurt at work, their job's insurance company controls or directs the treatment. So what you typically see is someone will go to the emergency room, and then subsequently the employer's insurance carrier gets involved, and they send the individual to like a doc in the box, so to speak, a Concentra or City MD. And what will end up happening many of times is that the injured workers go out and they treat for months without any true diagnostic imaging, often at times without seeing specialists, and it just kicks around. And many of times, in fact, people don't want to file these claims, but they haven't seen a specialist or undergone an MRI. They don't know what's wrong with them, and they're going 4, 5, 6 months without any sort of legitimate treatment. And in turn, the injured worker will go out and retain an attorney.
And what can we do, or what can you do at GGL to help these people that aren't getting the treatment that they really need because their treatment is being controlled by the defense?
Absolutely. This is one of the things that separates our firm from every other firm in the state. We, more than any firm in the state, by far, forward people for what we would dub unauthorized treatment. Treatment with doctors who I have forwarded the injured worker to. What this does, it assures, one, they're immediately receiving treatment. Two, it assures that they are given diagnostic images, and in turn, we're able to diagnose the problem early on through MRIs, CT scans, whatever it may be. Once we have the diagnostic images, we go out and we forward people to specialists. So in the event that the employer or the carrier denies someone medical treatment, if you retain our firm, the same day that you retain the firm, we forward you to a doctor if need be. This way you can get back on your feet, you have an understanding of what's wrong with you. And also, one of the things that is needed for me to win someone money in one of these claims is a series of records from a physician noting that the person in fact cannot return to work. So one, we make sure that they get treatment because we want to see people back on their feet. But two, we get people treatment instantaneously because if it's not instantaneous, the money that they are owed for their time out of work is delayed.
Now, you also talked a little bit about, well, before we get to that, let's go back now. How do you get these bills paid?
Sometimes it's easy, and the insurance carrier for a job will just go and pick up the bill voluntarily. Now, 20, 30 years ago, that was pretty common. Almost all of the cases were authorized from the inception. Believe it or not, Lawrence, years ago, people would get hurt at work. The insurance carrier would forward them to doctors right away. They would get legitimate treatment with specialists, and then only after the treatment concluded would they go out and retain a lawyer to win money for the permanent injuries that they sustained. That's not the case. That's probably less than 3% of all cases that we currently see. So what ends up happening now is many of times the claims are denied, people go out and retain an attorney, and then subsequently we have to essentially piece together all of the bills. It's almost like a bit of a puzzle. Someone's gone to the emergency room. Well, the hospital itself has a bill. Then the physicians within the hospital have a bill. Then the imaging center has a bill. So what we end up doing, we have to go out and forward authorizations to obtain not only all records, but all bills from every facility that a person is treated at. Once we have the bills, and assuming that the job's insurance carrier will not satisfy the bill, we have to go and file a dispositive motion within the court. What is that? It's a fancy way of saying a written document that compels the job and its insurance carrier to do something that it does not want to do. And in this instance, provide people with treatment, provide people with money for their time out of work, and satisfy bills for the treatment that people had obtained. And just to that end, it's become far more complicated. When I started doing this sort of work 15 years ago, if someone went to the hospital, the records were maybe 20 pages and there was a single bill from the hospital. Now, when someone goes to the hospital, there are hundreds or thousands of pages of records, and there are often 20, 30, 40 different bills from the one provider. So I've always been of the belief many people that don't want to file these claims are forced to file the claims because their job or its insurance carrier denies that they were hurt at work, and now they're saddled with hundreds of thousands of dollars in bills, and often for only a handful of visits to specialists or emergency rooms.
And we at GGL will fight to get those bills paid.
Every time, every time.
Now, a lot of times people are injured. You talked about falling from heights, like a scaffold collapses. And sometimes there's what we call a third-party claim. You want to
Correct.
explain the difference between a third-party claim and a workers' comp claim and how they tie in together?
Absolutely. So it's called a third-party claim because the individual who's receiving the benefit is not one that's named on the insurance policy. So the quintessential example of this would be an individual is driving, say, a truck for work, and then another driver rear-ends the truck. The person would be entitled to two claims. One, the third-party negligence claim against the person who caused the accident, and also the first-party workers' compensation claim. So in the ideal world, what would occur is an individual goes out and begins to obtain treatment through workers' compensation. Workers' compensation in New Jersey is primary, meaning that it is supposed to pay for an injured worker's medical treatment prior to other forms of insurance like personal injury protection or private health. So the individual would treat through workers' compensation, and additionally they would receive temporary disability money, 70% of the injured worker's average weekly wage for the entirety of the time that he is out of work. Thereafter, we would attempt to resolve the personal injury claim and win money for the permanent residual disability that the worker suffers. It's just a fancy way of saying compensate someone for permanent injuries they have sustained. Now, in addition to the workers' compensation claim, you can also get money in the third-party negligence claim for injuries that you've sustained. And there's some interplay between the two. In many instances, you collect 100% of the money from one suit and only a third of the money from the other suit. However, there are times where the person that causes the accident has limited insurance, and in turn, the bulk of the money and the entirety of the medical treatment are paid through workers' comp. One of the things that separates our firm from others is we have true specialists, certified trial attorneys in both areas. My department has recovered $500 million just in New Jersey workers' compensation claims. Few firms in the state, if any, can make a claim like that. So here, we line up the workers' compensation claim first, and people receive money and medical treatment in connection with that claim, and then we turn around and we try and resolve the third-party personal injury case. At our firm, because we have attorneys in both departments that handle these cases well, at the inception, we can sit down and develop a strategy. Is it more beneficial for this person to obtain the treatment through workers' compensation? Is there a limited insurance policy to where we have to line up the case in such a fashion to where the bulk of the money that the injured worker receives is in connection with the workers' comp case? I see many firms handle one side of the claim but not both, and in turn what happens, things get missed. Okay? There's a lot of strategy. At the very beginning, you have to determine what's the policy on the third-party claim, how are you going to get this person treatment, and who's going to satisfy the bills. And there are a series of points throughout the claim where we have to make a strategic decision. Do we want the individual to treat with the authorized workers' compensation doctors, or do we want to direct the care in connection with the personal injury claim? So it's a lot of interplay between the two. Our firm is well situated because we have almost a dozen workers' compensation attorneys and almost 30 personal injury attorneys. So by having a blend of the two, from day one we have a strategy, We understand how the claims are going to work. We understand where the people are going to receive money. We understand who's going to pay the bills.
Right, and that strategy is always about how do we put the most money in the client's pocket? Because there's been times where I've reviewed the third-party claims and said there's such a small policy, let's close out the third-party case
100%.
because the only people that are going to get paid are going to be the lawyers.
Correct.
Because in New Jersey, it's interesting because you can't get paid twice for the same injury. So if you resolve a case in workers' compensation, you're going to have to pay back 2/3 of that lien from the money from the third-party case. And sometimes there's not enough money to
100%
make it
correct.
worthwhile to pursue that third-party case. So we always tell the clients, we advise the clients which way to go. Should we go after both? Should we close out one case or the other? And generally, we don't close out the workers' comp case unless it shows up that there's no insurance or there's a real problem. And we usually keep that workers' comp case open. But there are occasions when we close down the third-party case because the only ones that would get paid are us. And there wouldn't be any money
Certainly.
for the client.
Certainly.
So we always try to do the right thing and fight for them. You mentioned also earlier about occupational cases, and that's something from repetitive motion. People think repetitive motion, oh yeah, that's carpal tunnel. Well, there's so many more ways to get injured through repetitive motion. Some people don't realize there's actually something called a workman's back from
Correct.
Lifting things for 20, 30 years of their lives. So let's talk a little bit about those types of
Just
cases.
to that, the condition is quite literally called occupational low back syndrome. So one of the things that we see, certainly in the day of logistics, the Amazons, the FedEx freight, there are people working in warehouses whose job it is to lift 400 packages an hour off of a conveyor belt. And it's easy when the package is the size of this ornament here. When it's the size of this chair or it's a refrigerator that you're lifting and you're lifting dozens of times an hour, it is very easy to perceive that someone could blow a disc in their back or that someone could fracture one of the vertebrae in their spine. Certainly there are a lot of jobs that require people to lift items and walk up and down stairs. A lot of damage to knees and to shoulders as well. So it's really any repetitive bending and lifting. It's not just the quintessential examples of, someone typing on a keyboard develops carpal tunnel. In fact, the vast, overwhelming majority of these claims that we've seen post-pandemic in the logistic-heavy world are people working in factories lifting items away hundreds of pounds off a conveyor belt and doing so dozens or hundreds of times an hour.
And how did those cases work as compared to somebody who's traumatically injured on the job because they dropped one of those pallets on their leg and it fractured their leg? But these repetitive cases, are they treated the same?
They are not. The occupational claims are very tricky in New Jersey. There are other states where occupational claims are often accepted. New Jersey, however, they're almost always denied. So what essentially happens is we have to file a claim against the job and every insurance carrier that it's had for the entirety of the exposure stint. So, for example, if an individual worked at a job for 10 years, we'd be filing the claim for the entirety of the 10-year period. Many large companies have a series of insurance carriers over that prolonged period, and in turn what ends up happening, it's us litigating the claim, sometimes against a dozen different lawyers for the insurance carrier. Each of these lawyers then goes out and denies the claim. So it puts the onus on our firm to immediately begin forwarding the person for what we would call unauthorized treatment directed by us, the attorneys. So key distinctions: one, the claims are tricky because they're denied 100% of the time. Two, they're tricky because it's often me fighting against a dozen different lawyers, all of whom are trying to advance a single strategy against our firm and the injured worker. And three, we have to go out and forward the injured worker for all of the treatment because 100% guarantee the claim is going to be denied. Just to that end, I would note, our firm, our department, we have an actual panel of physicians that we use. It spans every county in the state and is comprised of nearly 60 subspecialists. You need a hand surgery in Mount Arlington? No problem. You need a knee surgeon in Atlantic City? No problem. We have a panel of physicians that is statewide, so in the event that someone comes to the firm and they have an occupational claim, we can direct them for treatment no different than if they had a traumatic accident and the insurance carrier picked up or accepted the claim at the inception.
That's one of the benefits of going with the biggest workers' comp firm in New Jersey.
That is correct.
So, because you have all of those connections and so many doctors that we can use throughout the state. Now, what are some of the regulatory changes or any changes that our audience should be concerned with in workers' compensation?
It's funny. So there are a series of large national trends, some of which have made it to New Jersey, some of which have not. One that is particularly concerning is whether or not a rideshare driver can receive workers' compensation benefits. Under the current state of the law, in most instances in New Jersey, rideshare drivers are not entitled to workers' compensation benefits. So when someone is driving for Uber or for Lyft and they want to file one of these claims, we have to come in at the very inception and really sit there and audit these individuals' tax returns or W-9 information to try and gather the requisite materials to file a claim. Many states are moving in the direction that rideshare drivers are presumed to be employees. New Jersey hasn't gotten there yet, but if for nothing else, it is trending in the right direction. Okay. In another trend that I would suggest is the value of the claims has increased. So in short, there's a chart or a matrix, and it essentially enumerates every body part, and there are percentages of disability from 0 to 100 with increments of 2.5%. So 0, 2.5, 5, so on, all the way to 100. When I started doing this work, say 15 years ago, 22.5%, a routine figure given to someone who's injured their spine and had injections, that was about $30,000, maybe $25,000. Now those very claims are about $65,000. So inflation has caused the numbers within the chart or matrix, so to speak, to increase, and now these claims are substantially more valuable than they were. Of course, for me, it's great that the claims are worth more money, but they're also litigated a lot harder now than they were. 10 or 15 years ago, workers' compensation, which is no fault, the insurance carrier is supposed to voluntarily provide the treatment, the claims weren't defended that hard, frankly. All right, now, many of times, the workers' compensation claims are worth more than the auto accident portion of the claim, and in turn, the carriers have paid attention. The firms are much larger. Many of the firms that handle or defend these claims are 1,000-attorney firms based outside of the state of New Jersey. So the reality is the claims have become worth more money, but they're more litigious, the firms are larger, and the carriers are spending much more money to fight against the claims.
What are some of the takeaways you want to make sure our audience receives, keeps in their mind from this interview?
Absolutely. If you're hurt at work, not only in the traditional sense to where you've had one of these specific accidents, like falling from a scaffold, but if you've been exposed to, say, occupational exposure from repetitive bending and lifting, one, report the injury to your employer. If possible, have your employer draft a report. Number 3, get medical treatment. And when you get treatment, be honest with the physicians. Tell them that you were injured at work. Do your best to track any bills for unauthorized treatment in the event that you go to the emergency room, whatever it may be. And when you're looking for a lawyer, you call GGL. We've recovered in excess of $500 million just in New Jersey workers' compensation claims.
And why else should they call GGL in specific? Why should they ask for Michael Tomasino?
Well, we take a great level of pride in the way that we handle claims. We essentially were the first firm to start forwarding people for unauthorized treatment or treatment with doctors that we direct them to, assuring that people get quality, affordable medical care. That is number 1. Number 2, we have the largest panel of physicians in the state. In the event you've sustained a significant injury and need true specialists, we will find one for you. There are very few firms that can say that. Number 3, we have certified trial attorneys in both workers' compensation and in personal injury. And in the event that you have a claim that has both the workers' compensation and a personal injury hooked to it, we can come up with a strategy day 1. Also, when you look, the track record of success here is second to none. It's absolutely second to none in the state. We handle claims in every county in the state. We have made appearances in every county in the state, and something that's very different from other firms. From the day the case walks through the door, we prep the claim as if it were to proceed to trial. And in that fashion, we are able to maximize recovery for the clients. Do most cases go to trial? No, probably less than 5%. But let's be clear, we prepare every case as if it's going to proceed to trial from the day the client arrives.
And that's why we can maximize the value of every claim. Thank you. It's a pleasure to have Michael Tomasino here, one of the top attorneys in the state of New Jersey. We're lucky to have him at GGL.